you can't just be allowed to run down everybody and get up and walk because you are Afenyo Markins. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afenyo Markins, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
The minority leader could have made a general statement that the minority opposes the process and that they are, as a result of their opposition, either not participating, okay, or that they have questions to be posed to the nominee with respect to why this should be happening at this point in time. That is the context within which I think he should have situated his comments. But the approach that he used was basically to bring the motion that was dismissed by Mr. Speaker back on to the agenda of Parliament through this committee. And that was, to me, regrettable. And it was a sheer waste of time for the entire committee. You can imagine that we spent
almost
about 2
hours.
hours just on his preliminary comments.
Right.
And then also it doesn't show respect to the nominee. Okay, there are 3 branches of government. Most of the time, I want to say that there are 3 co-equal branches of government. We cannot bring the potential head of one of the branches of government to sit here and wait for us for 2 hours just to debate amongst ourselves, whether or not his vetting should proceed. So I think that is highly regrettable. But that is all I can say for now.
So whatever that happens, the affirmation will be done. The acting Chief Justice will be affirmed.
It will come down to a vote.
Right.
And if it comes down to a vote, we are on the side of the president's nominee. And we have the numbers to do so. We are not abusing our majority. We are basically asserting, our right to confirm the nominee that has been put forward by His Excellency the President.
What happens if there is a walkout from Parliament, from the minority side?
Well, we'll have to continue because the practice and convention of Parliament is that once a quorum has been formed, that quorum continues till the end. And so we have formed a quorum. In fact, the majority side alone has quorum to be able to conduct the business of the House. But given the fact that the minority has joined us, a quorum has been formed, and if they do walk out, we will continue the business to its logical conclusion.
Well, thank you for having us. So we're speaking to Dominic Ayine, that is the Attorney General.
Just hold it a second. Yes, Honorable Ayariga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. Order 122. And 1, 2, 3. I want you to focus on those 2 orders. 1, 2, 3 talks about content of speeches, whereas 1, 2, 2 provides the grounds on which debate can be interrupted. So I come under order 1, 2, 2. But my objection is founded on content of speeches. I've heard the ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. 1, 2, 3 says, a member shall not raise any question 1, 2, 3, 5. A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. I recall that just a couple of days ago, I think Thursday, the same member brought a motion to the House trying to stop this committee from sitting to vet the nominee. The matter was exhaustively debated, and you, Mr. Speaker, gave a ruling. Subsequently, the Speaker himself, because you sat as a Deputy Speaker, the Speaker himself came and recounted the motion and also gave a ruling. So this issue about the propriety or otherwise of whatever happened has been raised on the floor, debated extensively, and a ruling given. Apart from that, Order 1237 says that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib, there is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, the majority leader is clearly acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. Is it this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. And then he says that I am debating. Who is debating here? Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks, or see that to you as a chair of the committee to read it for Hansard. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make any progress with that. Again, the 1, 2, 3 that he relies upon. He says that the conduct of the Speaker, the Chief Justice, members and Justice of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect. Have I raised any issue that is situated within the context of 123.7 to warrant this so-called objection? Chairman.
Honorable members, can we have some order?
Chairman.
Honorable members, can we have some order and listen to the minority leader in silence?
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views on matters of national interest. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right? Express it. We have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control. Can't I have these bona fides also that have to be obstructed by the majority leader when you have every unfettered right to raise your issues? Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of the minority, he can seek your leave to also make his opening remarks. By the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me. From J.H. Mensah's era, he and J.H. Owusubempah, all the way to Alban Bagbin, MP for now Dole Kalio, and minority leader as he then was. The videos are there. Hansard is there. The Honorable Bagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chairman Sabonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is You are majority, so we cannot even say a word. We must have our rights. These are our rights. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more
Honorable
decency.
Minority Leader, your point is made.
Yeah,
Yes, you have listened to the response.
Right, Honorable.
Honorable members, it's not every issue that will necessarily call for the chair making a ruling. But honorable members, I indicated as a preliminary issue that let us all operate within the rules. Honorable members, may I add that we need to also observe the principle of brevity. Yes, what do you have to say?
Chairman, if you read rule 1233, where in the opinion of the speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where in the opinion of the speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the speaker may order that the member withdraws those words or withdraw and apologize. Mr. Speaker, when we came into this chamber, this committee meeting room, and you started, you referred to the nominee as Chief Justice. When you referred to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honourable members, Honourable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee, let us all observe that rule and refer to him as such.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again.
On the 22nd April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honourable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honorable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, if I may read, to serve as a guide to all of us. It states that a motion shall relate to a definite issue and not revive the consideration of a matter which had been considered in the same meeting unless new matters have arisen. Honourable members, by necessary implication, whether a motion or not, the principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honorable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter, I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On April 22nd, 2025, Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship, Gabriel Scott Puama, to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
in the
Our
language
rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offended.
But
the rules clearly are offended. Chairman, the rules say that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Let me, Chairman, let me respond to him. There might.
You see, I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman,
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to.
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Ayariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention that my reference to the committee's work amount to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of her ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayariga, please, bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayariga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? Where you have the right to say your own, you are the leader of the House. You have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. we
Honorable,
as members of the
Honorable
public
Minority Leader, kindly
criticize
conclude for me.
the work of even
Please
the
conclude for
judiciary.
me. Conclude
so
for me.
I beg you, leader.
Conclude.
We all agreed, Chairman. You
Conclude.
know.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now
I have listened to
an issue we don't. What is
minority
this over protection?
minority leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Poma is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity here and then to make comment. Therefore, for you jumping into a conclusion to say that their report amount to a travesty of justice without any of them having the opportunity to respond offends our rules. I will consequently order that anything in relating to the committee and Justice Poma should be expunged from our record. That is my ruling.
Chairman,
Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That said, I will proceed. Yeah. We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of our country.
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling.
This one is friendly. Opaque. It's friendly. Opaque.
Yes, Majority Leader.
Mr. Chairman, please. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honourable Majority Leader, you've made your point. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman.
And keep to the rules, because I will object to anything that violates the rules.
But when we do this, it's not okay. Mr. Chairman,
Minority Leader, don't be preemptive. Majority Leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains
Mr. Chairman,
sub judice,
I object.
There is a nomination
I object.
to replace.
I object.
Can have the floor.
Araba Isaba Toko.
Honourable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from random commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this House, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings, and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are Afenyo Markins. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afenyo Markins, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away whilst I sit in this committee.